Dear learners, today we are going to discuss the golden thread in the Charter of the United Nations, that is, we are going to highlight the idea of human rights throughout the provisions of the UN Charter. We will discuss every part of the Charter for the purpose. Therefore, this lecture has been divided into two parts. My focus in these two lectures would be not only to mention the provisions and to analyze those provisions, but also to apprise you of latest examples of how these provisions are being implemented. In the first part of the lecture, we discussed the Charter from its preamble till Chapter 8. In this second part of the lecture, we will discuss UN Charter's Chapter 9 onwards with respect to the human rights. Let us begin. Chapter 9 of the Charter speaks for international economic and social cooperation, which is actually intrinsic to all human rights efforts. Article 55 of this chapter says that with the view to the creation of conditions of stability and well-being which are necessary for peaceful and friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, the United Nations shall promote higher standard of living, full employment and conditions of economic and social progress and development, and observance of human rights and fundamental freedoms for all. Further, Article 56 says that all members pledge themselves to take joint and separate action in cooperation with the organization for the achievement of the purposes set forth in Article 55. That is why each state has individual responsibility to ensure protection of human rights. Article 57 provides that the various specialized agencies and their role to promote the cause of human rights, which we will discuss further. Some of these specialized agencies of the UN are Food and Agriculture Organization of the United Nations, International Civil Aviation Organization, International Labour Organization, etc. In total, there are 15 specialized agencies of the UN. Article 58 mentions clearly that the UN shall make recommendations for the coordination of the policies and activities of the specialized agencies, and Article 59 further provides for creation of any new specialized agencies. Also, Article 60 fixes the accountability of all these agencies towards the General Assembly and under the authority of the General Assembly in the Economic and Social Council, which shall have for this purpose the powers set forth in Chapter 10. Please do listen to the lecture on Economic and Social Council, which is part of this very course only. It was important to discuss all the provisions of Chapter 9 of the UN Charter, as it leads us to yet another very important chapter, that is the Chapter 10, which is dedicated to the ECOSOC. This organ of the UN has single-handedly dealt with a variety of human rights issues and has established a robust monitoring system as well. As I requested earlier, please check full lecture on ECOSOC, which is also part of this lecture. The next chapter is Chapter 11, which says Declaration regarding non-self-governing territories. The United Nations was established in the backdrop of colonialism, and a lot of countries were not politically free. To add to the problem, the world wars further deprived the people from the colonized world and made them more vulnerable and exploited. This part of the UN Charter was drafted carefully to address the concerns emerging out of the imperialist world. Let us read the provisions to understand this better. Article 73 provides that members of the United Nations which have or assume responsibilities for the administration of territories whose peoples have not yet attained a full measure of self-government recognize the principle that the interests of the inhabitants, and to this end would work to ensure, with due respect of the culture of the peoples concerned, their political, economic, social and educational advancement, their just treatment, also to develop self-government, to take due account of the political aspirations of the people and to assist them in the progressive development of their free political institutions. Further, it also says to enhance international peace and security, etc. Further, in Article 74, it is provided that members of the United Nations also agree to the general principle of good neighborliness towards the areas falling under this chapter. So, this chapter clearly is speaking for the protection of civil and political rights of the people. Chapter 12 established an international trusteeship system in order to implement the chapter 11 which we just discussed, along with chapter 13 which established the trusteeship council. I would request all of you to listen the lecture on this very topic, which is also part of this very course. Chapter 14 of the Charter provides for one of the best contributions of the United Nations to the international human rights system in general and to international justice system in particular. The chapter provides for the International Court of Justice. Article 92 provides the International Court of Justice as principal judicial organ of the United Nations. It shall function in accordance with the annexed statute to the Charter. Article 93 declares all members of the United Nations are ipso facto parties to the statute of the International Court of Justice. The state which is not a member of the United Nations may also become a party to the statute of the International Court of Justice or ICJ on conditions to be determined in each case by the General Assembly upon the recommendation of the Security Council. Switzerland, Liechtenstein, San Marino, Japan and Nauru fell into this category before joining the United Nations. Article 94 says that each member of the United Nations undertakes to comply with the decision of the International Court of Justice in any case to which it is a party. A party may have recourse to the Security Council against the other non-compliant party, and the Council may, if it deems necessary, make recommendations or decide upon measures to be taken to give effect to the judgment. We have already discussed the powers within the range of Security Council, including sanctions as well as armed action. Further, Article 95 allows member states to resort to other tribunals as well in order to resolve the dispute. Article 96 provides that the General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. Also, other organs of the United Nations and specialized agencies which may at any time be so authorized by the General Assembly may also request advisory opinion of the court on legal questions arising within the scope of their activities. By its advisory opinion and also by deciding matters of conflict between members of the states, the ICJ has worked towards the consolidation of international human rights. Let us have a look at some such examples. The ICJ can be said to contribute directly to clarifying and strengthening the legal basis of responsibility to protect doctrine, which is aimed at protecting populations from mass atrocity crimes, namely genocide, war crimes, crimes against humanity, and ethnic cleansing. There is another different example where ICJ is of great relevance. There is a recent Indian case in the ICJ. On 8th May 2017, India filed an application instituting proceedings against Pakistan in respect to a dispute concerning alleged violations of Vienna Convention on Consular Relations of 24th April 1963 in the matter of the detention and trial of an Indian national, Mr. Kulbhushan Sudhir Jadhav, who had been sentenced to death by a military court in Pakistan in April 2017. India claimed that Pakistan had failed to inform it without delay of the arrest and detention of its national. It further contended that Mr. Jadhav had not been informed of his rights under Article 36 of Vienna Convention on Consular Relations and that India's consular officers had been denied access to Mr. Jadhav when he was in custody, detention and prison, and had been unable to converse and correspond with him or arrange for his legal representation. On the same day, India also filed a request for the indication of provisional measures, requesting the court to direct Pakistan to take all measures necessary to ensure that Mr. Kulbhushan Sudhir Jadhav is not executed, and to ensure that no action is taken that might prejudice the rights of the Republic of India or Mr. Kulbhushan Sudhir Jadhav with respect to any decision the court may render on the merits of the case. By an order dated 18th May 2017, the court directed Pakistan to take all measures at its disposal to ensure that Mr. Jadhav would not be executed pending a final decision in the case, and to inform the court of all the measures taken in implementation of that order. In its judgment of 17 July 2019, the court concluded that India's application was admissible. Please do read more on this very interesting case. In its advisory opinion on reservations to the Genocide Convention of 1951, with regard to reservations to the 1948 Genocide Convention, the ICJ has cautiously reminded states that given that the intention of the General Assembly was that as many states as possible should join, the object and purposes of the Genocide Convention would limit both the freedom of the making reservations and that of objecting to them. Let us now discuss chapter 15, which is dedicated to the Secretariat of the United Nations. According to Article 97, the Secretariat shall comprise a Secretary General appointed by the General Assembly upon the recommendation of the Security Council. He shall be the Chief Administrative Officer of the organization. Till date, the Secretary Generals are very popularly known and strong personalities at the UN. Do you know who is the present Secretary General of the UN? Please do check. As per Article 98, The Secretary General shall act as Chief Administrative Officer of the General Assembly, and also for the Security Council, also for the Economic and Social Council, and of the Trusteeship Council, and shall also perform such other functions as are entrusted to him by these organs. The Secretary General shall make an annual report to the General Assembly on the work of the organization. I would like to bring to your attention here that it is with the utmost efforts of the Secretary General that all the human rights works are done at the level of all these organs of United Nations. The Secretary General may remain in direct contact with the Security Council under Article 99 to bring to the attention of the Council any matter which in his opinion may threaten the maintenance of international peace and security. Article 100 puts the Secretary General in strong position, as he shall not seek or receive instructions from any government or from any other authority external to the organization. The Secretary General appoints the staff under regulations established by the General Assembly as per Article 101. The paramount consideration in the employment of the staff and in the determination of the conditions of service shall be the necessity of securing the highest standards of efficiency, competence and integrity. Due regard shall be paid to the importance of the recruiting the staff on as wide geographical basis as possible. As I said earlier, several charismatic and dynamic persons have been on this post. The United Nations first Secretary General, Trygve Lie, called it the most difficult job in the world. Some of the difficulties lie in the job description itself. Kofi Annan, for example, was considered an activist, world moderator style of Secretary General, and he also won a Nobel Peace Prize. His successor, Ban Ki-moon, was seen as more of an administrator, and he successfully pushed forward the Paris Agreement and also increased the number of women in the UN's senior management positions. On Human Rights Day on 10th December 2020, the present Secretary General of the United Nations has said that human rights must remain at the front and center of COVID-19 response worldwide. It is a very difficult job indeed, as in the book Secretary or General, Simon Chesterman and Thomas M. Frank say, the office holder is sometimes treated as an errand boy and punching bag, expected to be both an independent political force and a public servant. Let us move on to the next chapter, which is chapter 16 of the UN Charter. It includes the miscellaneous provisions. However, these are also very important. Article 102 highlights the importance of UN treaties, in this case the treaties on human rights, and that these must be duly notified by the Secretariat so that it is available to all. Article 103 very interestingly makes clear that the obligations of the member states under the UN would be held prior in case of any conflict between the obligations of the members of the United Nations arise. Article 104 mentions that the United Nations shall enjoy the territory of each of its members such legal capacity as may be necessary for the exercise of its functions and the fulfillment of its purposes. Further, Article 105 says, the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. Representatives of the members of the United Nations and officials of the organization shall similarly enjoy such privileges and immunities as are necessary for the independent exercise of their functions in connection with the organization. The General Assembly may make recommendations with a view to determining the details of the application of paragraph 1 and 2 of this article, or may propose conventions to the members of the United Nations for this purpose. Together, the Article 104 and 105 became the basis for the Convention on the Privileges and Immunities of the United Nations, adopted by the General Assembly of the United Nations on 13th February 1946. Article 1, Section 1 of the Convention declares the United Nations as possessing a judicial personality with the capacity to contract, to acquire and dispose of immovable and movable property, to institute legal proceedings. Under Article 3, Section 9 of this convention, the United Nations shall enjoy in the territory of each member of its official communications treatment not less favorable than that accorded by the government of that member to any other government, including its diplomatic mission. No censorship shall be applied to the official correspondence and other official communications of the United Nations. The convention gave immunity to the persons of the UN, which becomes very crucial when special rapporteurs, etc., or the team of the fact-finding missions are doing their job to uphold human rights. The next is Chapter 17, which is dedicated to transitional security arrangements. Article 106 of the UN Charter seems to be a burden of history in the UN Charter. It provides that the big four countries which are party to the four-nation declaration signed at Moscow on 30th October 1943, along with the fifth country France, shall continue their efforts towards international peace and security. This would be or may be in addition to the pooled forces by all the member states under Article 42 and 43 of the Charter. While the provision was kept to work for global peace, however, the critics have not appreciated this article as it abridges the powers and purposes of the United Nations. It is important to mention here that United Nations has defined transitional justice as the full range of processes and mechanisms associated with the society's attempt to come to terms with the legacy of large-scale past abuses in order to ensure accountability, serve justice and achieve reconciliation. United Nations work on transitional justice is based on international human rights law, international humanitarian law, international criminal law and international refugee law. Let us move on to the next chapter, chapter 18, which is dedicated to amendments. Amendments have been discussed under Article 108, which prescribes amendments procedure to the present charter. It says it shall come into force for all members of the United Nations when they have been adopted by a vote of 2/3 of the members of the General Assembly and ratified in accordance with their respective constitutional processes by 2/3 of the members of the United Nations, including all the permanent members of the Security Council. Let us look at amendments made in the Charter. In 1965, Article 23 was amended to enlarge the Security Council from 11 to 15 members. In 1965 again, Article 27 was amended to increase the required number of Security Council votes from 7 to 9. In 1965, again, Article 61 was amended to enlarge the ECOSOC from 18 to 27 members. In 1968, Article 109 was amended to change the requirements for a General Conference of Member States for reviewing the Charter. In 1973, Article 61 was amended again to further enlarge ECOSOC from 27 to 54 members. The amendments made to the membership of the ECOSOC were motivated to improve the working towards human rights. Chapter 19 talks about ratification and signature to the UN Charter. Article 110 and 111 declares that the Charter draws its authority by ratification made by member states which are sovereign, and also that this Charter must be adopted after due constitutional process, which is one of the bases to protect human rights. So, we just discussed a very important document on international human rights, that is the UN Charter. I would suggest to all of you to go through this topic again, as there is a lot to know about it. This would be it for this lecture. Take care till we meet again with other similar topics. Thank you.